All right, good morning. We're on YouTube now. Uh, Court will begin with the July 23rd, 2020 docket. And Mr. Palacios, good morning, sir.
Good morning, Judge.
And Mr. Delgado, good morning.
Morning, Judge.
We have here CL 20-2582D, State of Texas versus Luis Araujo. And
Good morning, Judge.
Yes, sir.
Toribio Palacios for Mr. Luis Araujo. Judge, we applied for an occupational driver license.
Okay. Mr. Delgado, have you had a chance to review the application?
I did, Your Honor. The state would be opposed on this defendant has, I believe, 4 DWIs, 2 in 2012, 1 in 2017, and this one in 2019. He did receive a previous occupational and back in 2018. And I believe the interlock lease that was uploaded, Your Honor, it was in Spanish, but from what I understood, it expired on the 14th of this month. And I also didn't see an essential need on the petition, Your Honor.
All right, Mr. Palacios.
Judge, he does have the interlock and continues with the interlock, Judge. He does work. So the essential needs is there, Judge, so he go and come to work. He does have the latest DWI, which is a felony, Judge, but he needs his license to work, Judge. And that's the reason he got the SR22, which is a high-risk insurance, and the interlock installed, Judge. And he continues to carry that. As long as the court orders the interlock, I don't think he's should be allowed to drive, Your Honor.
Okay, and as long as he uses it the way it's supposed to be used, then there shouldn't be any problems.
That's correct.
Mr. Delgado?
Your Honor, the state would still oppose, given that he was given an occupation in 2018 only to pick up another DWI, third or more, in 2019. Should the court be inclined, the state would request not only the interlock, but also the 12-hour restrictions with geographic restrictions. But the state would urge the court to oppose.
Okay. And Mr. Palacios, did I hear that he's a CDL driver?
Judge, he is. Well, I'm not sure. I don't think he has a CDL, Judge. I think he does use his license to come and go to work. I don't think he's qualified for an occupational license under the CDL, Judge. But okay, he does have regular driver license, and he uses it to go and come to work, Judge, and for essential needs right now, Judge.
All right. And Mr. Araujo, you're there, sir. Can you hear me?
Yeah, I can hear you, sir.
Oh, okay. Now we're gonna go ahead and grant it, of course, with the with the interlock device, but you gotta use it the way it's supposed to be used according to the probation office and department and whatnot. You gotta blow in it when you're supposed to, and don't let nobody else do that for you. And no alcohol consumption while the case is pending. Okay, sir?
Yes, sir.
All right, you understand that? Otherwise, we won't ever issue another occupation license again. So be very careful. We'll go ahead and grant it with the state's opposition. Okay?
Thank you, Judge.
All right, submit the order, Mr. Palacios.
I will. You have a good day,
right,
Judge.
Thank you. Have a good day. Thank you.
Be safe.
Be safe.
Judge may be excused?
Yes, sir. You may be excused. Thank you. I'll see you this afternoon, right?
Yes, Judge. Thank you.
All right. We'll see you. Mr. Okay. Mr. Araujo, you're excused.
Yes,
okay, sir?
All right. Thank you, sir.
Thank you. All right. Let's go to CL 20-0037D, West Kentucky Country Barn LLC versus Francisco Rios, Guadalupe, Bentoncourt, Huerta. Yes, sir, Mr. Is it Mr. Halliburton?
Yes, Mr. I'm here for West Kentucky, Your Honor.
All right. Good morning, sir. And is it your motion for new trial?
Yes, it's my motion for new trial, Judge. On behalf of Francisco Rios Jr. and Guadalupe Bentoncourt Huerta, who are present in the courtroom today.
Okay.
Present in my office. Now, Mr. Rios, I filed this as soon as I could because I didn't want to blow the 30 days motion for new trial. But Mr. Rios showed up to my office. He believes he got sunstroke yesterday, and he's not feeling too well. So he is sitting at a distance from me. I don't know whether to proceed today. I don't want to blow the 30 days So I wanted to let the court know that. I did get a response to my motion for new trial. My motion for new trial is basically a confusion that Mr. Rios had, and I can have him testify as to that, Your Honor. This suit was filed on the 2nd of January this year, and my clients were served by substituted service pursuant to a motion and an order granting it. They were served, and the service was returned, and the default judgment was scheduled by the court. Now, I looked at the COVID orders, and it appears that you can schedule a default judgment after, I believe, May 18th. So it appears from the face of it that the hearing could be had under the current COVID orders, but Mr. Rios came to my office and he'll explain under oath that he was confused about the date and he didn't show up, but he was intending to show up and offer up his defense.
Now, Mr. Guerrero, when was the default judgment signed?
The default judgment was signed by the court on the 24th of June.
Okay, June 24th. Okay, and the hearing was held?
The hearing was held, let me see here. It was the jury, that was the date of the hearing. Yeah. June
Oh, that was
24th.
the same date. Okay, same date. All right. He was served by substituted service. Let me see here, and it was default judgment as to both defendants, Rios and Huerta.
Yes, Your Honor, it's to both defendants.
Okay.
And they're both here in my office.
Okay. And you wanted to put some testimony?
Absolutely.
All right.
Other than
All right.
this,
Who are you gonna call first? It'll be Mr. Rios.
Mr. Rios, yes, sir.
No one is interpreting?
No, Mr. Rios speaks English.
Okay. All right. Let's see here. Can you hear me, Mr. Rios?
Yes, sir, I can hear you.
All right. You are Francisco Rios Jr., right, sir?
Yes, sir.
All right. Would you please raise your right hand? You swear the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Mr. Guerrero?
Yes, thank you, Judge. Mr. Rios, are you the defendant in the case where you were sued by West Kentucky Country Barn LLC?
Yes, sir.
And Mr. Rios, were you ever served with the citation in this case personally?
No, sir.
Okay, now there was a hearing set for June 24th, 2020. Are you aware of that date?
I showed up to court and it was one day después de la court.
After the court.
Yes,
So you showed up on the wrong date. And that you intend to offer a defense to the judge regarding the debt?
yes, sir.
Okay, and are you saying to this court that that the debt is not true and correct? That's what you're saying?
Yes.
Okay. Mr. Rios, and was it an honest mistake, the fact that you didn't show up for the right date?
Yes, sir. I had all the intentions to go, but with all this happening around us and all this, and the stress besides everything else, I just got sidetracked and I went into the wrong day.
Now, sir, I'm looking at you and maybe the court can't see, but you're breaking in a cold sweat right now. Is that correct?
Yes, sir.
All right, Judge, I'll pass the witness at this point.
Okay. The question I have is, you said Mr. Rios came to court like the day after. Did you go to the courthouse?
Yes, sir.
The actual courthouse?
Yes, sir.
Okay, because the hearing was held Zoom, right? We haven't gone to the courthouse in 4 months, so the hearing was held via Zoom. All right,
Sir.
Mr. Halliburton. Yes, sir.
Just a couple of questions, Your Honor.
Yes, sir.
Mr. Rios,
Yes, sir.
my name is Kerry Halliburton. I'm the attorney for West Kentucky. I wanted to confirm you did get the notice for the default hearing. Is that correct?
Yes, sir. I got a letter.
Okay. And what is your defense to the debt?
I didn't really get any paperwork, or I didn't get anything. It was just a court date. And like I said, I got confused and distracted because of everything that's going around. I ended up in
What-
trouble.
And I'm sorry, you had mentioned a moment ago that the debt was not just and true. What is your defense? I mean, what are you basing that on, that you don't owe it? Why are you saying you don't owe it?
I'm just saying that I didn't get to see anything on paper that what I owed or what this company is asking for. I didn't get no paperwork. I didn't get anything. All I was asked to go to court, which I did, but like I said, I went the wrong day.
That's all I have, Your Honor.
Okay, is this a credit card debt?
No, it's a lease purchase on a portable building.
Oh, okay. I got you.
It's a commercial debt, but I'm not sure if it's secured, but it's a commercial debt.
Okay, on a building, right? On one of those barns or something?
Yes.
Oh,
Yes.
okay, I got you. Okay, now is Guadalupe Huerta gonna testify?
Yes, Judge, I'll be brief. I'm gonna put the camera towards her.
All right. Thank you for your testimony, Mr. Rios. Let me go now to Guadalupe Bentoncourt Huerta. Good morning, ma'am.
Judge, Ms. Huerta doesn't speak English.
Okay, let me get my interpreter here. Okay. Just be a couple of questions. I won't be too much. All right, Miss Huerta, can you hear me?
Señora Huerta, ¿me escucha?
Sí.
Yes.
Okay. Please raise your right hand, ma'am.
Por favor, levante su mano derecha.
You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
¿Usted jura que el testimonio que va a dar es la verdad, solamente la verdad y nada más que la verdad?
Sí.
Yes.
All right, you can put your hand down,
Puede
ma'am,
bajar su mano.
and listen carefully to the
Y por
questions.
favor, escuche a las preguntas.
Okay, go ahead, Mr. Guerrero.
Thank you, Judge. Ms.
Yes,
Huerta, do you know that you're being sued by West Kentucky Country Barn LLC?
Señora Huerta, ¿usted sabe que usted ha sido demandada por la compañía West Kentucky Country Barn LLC?
Sí.
Yes.
And this lawsuit, if you're aware, is regarding the debt.
Y esta demanda, si usted sabe, es tocante a una deuda.
Sí.
Yes.
Do you owe that debt to West Kentucky Country Barn LLC?
¿Usted debe esta deuda a esa compañía, a West Kentucky?
Sí.
Yes.
Okay. And do you know what that amount that you owe is?
¿Usted sabe la cantidad de esa deuda que se debe?
No.
No.
So you don't know the right amount as we speak today.
So, hoy, así como platicamos, usted no sabe la cantidad.
No, porque nunca nos mandaron un reporte cuánto se debía.
No, because they never sent us a report as to how much we owed or was owed.
Oh, thank you. Then I'll pass the witness.
Gracias.
Okay, Mr. Halliburton.
Just one question, Your Honor. Ms. Betancourt Huerta, do you admit that you received notice of the default hearing?
Usted hoy puede decirle a la corte que usted recibió notificación de la audiencia que se tomó a cabo el 24 de junio.
No entiende.
No entiendo. No
Can you
entiendo.
repeat the question, sir, please?
Did she receive notice of the hearing that they claim they miscalendared?
¿Usted recibió notificación de la audiencia que la corte le mandó que ustedes dicen que lo pusieron en la fecha incorrecta?
Oh, sí.
Yes.
And one last question. What is your defense to the debt.
¿Qué es la defensa de usted tocante a la deuda que se debe? ¿Qué es su defensa?
O pues nada más que si hay tiempo para pagar o no sabemos la verdad cuánto debemos porque nos cansamos mucho de estarles pidiendo o sea, lo que nos dé, el saldo que estamos pagando y luego que nos mandaran recibos, cuánto es lo que nos quedaban para pagar porque ya era casi ya lo final.
The only thing is that we really don't know how much is owed, and we requested receipts. We never got any receipts as to the actual amount that was owed. We made payments, and it's my understanding that we're almost finished paying the amount.
That's all I have, Your Honor.
All right, Mr. Guerrero, anything else, sir?
Nothing else insofar as testimony, Judge.
Okay, and I was gonna ask Ms. Guerrero, I'm sorry, Ms. Huerta. Did you also show up at the courthouse on the 25th, on the day after the hearing?
Señora Huerta, ¿usted fue en persona a la corte el día después de la audiencia, el día 25 de junio?
No, porque no estaba aquí.
No, because I wasn't here.
Ah, okay, so she didn't go, but I think I heard earlier that Mr. Rios did show up the day, like the 25th, I guess, because the hearing was on the 24th. But on the notice, I think we always put in there that there's a Zoom hearing, right?
Yes, sir.
And with a Zoom
ID. and
ID
password.
and password and so forth. But anyway, his allegation is that he did show up at the courthouse, but the day afterwards, the day after. Okay. Anything else by anybody else, Mr. Halliburton or Mr. Guerrero?
I didn't know if I just have a brief closing
Yes, sir.
on law whenever you want.
Yeah. Go ahead, sir.
You want me to go?
Sure. Yes, sir. Yeah.
Okay. I think if you look at the motion, there is no disagreement on the law. It's relatively simple. It's just that this fails on its face. I think as you're picking up, Your Honor, with respect to Mrs. Huerta, there was no affidavit submitted with the motion. There is no allegation with respect to any excuse. Apparently, she did not even try to show up. Although they admitted the motion, they got notice, and there is no meritorious defense asserted. With respect to Mr. Rios, to me, that is the definition of conscious indifference. They admit in the motion that they were served, they got notice of the service, did not file an answer, admit that they got the notice of the hearing, but say they were just did it wrong. Well, that's kind of the definition of conscious indifference. If that's all it took, every one of these would get a new trial. And he did not set up a meritorious defense. And this is just one that they just did not do it right. And the claims that they didn't know how much owed, that's very conclusory in general. That's what anybody would say. The judgment sets that out. And this ought not be the one that gets a new trial. It's certainly as to her. And that's all I have, Your Honor.
All right.
Judge,
And Mr.
I can respond. Your Honor, typically speaking, a lot of our community and both, every part of Texas lacks sophistication. And this is a couple that lacks that sophistication. I mean, Zoom means a lot to me when I see it, but to a person who is not familiar with these type of formats, especially older generation, it's almost meaningless to see Zoom. Now, insofar as the meritorious defense, the defense is that the debt is not disclosed and is not just and true. This is basically a defense, and both of them testified as to that. Insofar as the notice, it's obvious that both of these, my clients, as husband and wife, depend on each other. It's a community estate. So the effort of one member of the community to go ahead and show up to a hearing who lacks sophistication along with her spouse is defensible for both of them. And today is a testimony regarding the issues. And all this testimony, the testimony of the notice, the testimony of the erroneous date, the testimony that the debt is not just and true, is at best, or at least uncontroverted. So this motion is a very meritorious motion. In fact, I'm surprised counsel is taking the position he's taking. Of course, he's advocating for his client, but this is not conscious indifference. Conscious indifference is, you know, a flippant attitude where a person gets a notice and says, I don't care, I'm not going to show up, and then comes and complains. This gentleman made an effort. He made a date error, and he made an effort to show up. He's here before the court, and he's asserting that the debt is not correct because he's asked for a summation from Kentucky about how much is owed, and he's never received that until now that the lawsuit's filed. So that's our presentation, Judge.
Okay, one moment, Mr. Halliburton and Mr. Guerrero, one moment. All right, gentlemen, I was just noticing that on the notice for the default judgment, in the order stating hearing date, we do mention that they ought to show up at the courtroom at 11 o'clock at County Court Law number 4 in Hidalgo County, Texas. But just below that, we have the meeting ID and the password ID numbers. But I know what we're doing right now is way on top where it says order setting hearing date. We'll put there real big via Zoom. We didn't do it on this one, that's for sure. But in this one, then the order setting hearing date, we did advise everybody the hearing will be at the courthouse, court number 4. But it does mention the meeting and the password below. But I mean, I guess like Mr. Guerrero said, only sophisticated people can understand that, or what? Is that what you said, sir?
Yes, sir. Yes, Judge.
Well, let me go. Oh, by the way, I have a question. How much was the judgment on this one? The default judgment? Do you know it, Mr. Halliburton?
I think it was for possession, and then I think about $2,400 plus
Okay.
$1,200 of attorney's fees. Is it?
Okay.
Oh,
On
not looking-
possession.
It's for
Okay.
possession.
Also possession, right, of the barn?
So it ends up being a form of a garnishment. So,
Well,
so that opens up a whole new set of COVID rules I need to go look at too.
okay. Let me go ahead and take this matter under advisement.
Thank you, Judge.
Let me review everything again, and also consider what I just heard in testimony and argument of counsel, and let me come up with hopefully next week a
Okay.
ruling. Submit your proposed orders, please.
Yes, Judge.
Okay.
We will.
All right, gentlemen, you may be excused. Thank you so
Okay.
much and be safe.
Thank you both.
Yes, sir.
Bye-bye.